concretely demonstrated to court by verifiable facts and by objective and serious reasons need and justification for a recourse to the military court. 2. The minority observed that military courts can only have jurisdiction in relation to specific class or category of persons and specific offences which ordinary courts are not in position to try. 3. The jurisdiction of the court-martial can only extend to cases reserved for specialized courts such as Anti-Corruption Court under the Anti-Corruption Act, International Crimes Division under the Anti-Terrorism Act. 4. Military courts cannot have jurisdiction over offences which require the consent of the DPP. The consent of the DPP. 5. Civilians cannot commit or be tried for service offences even when they abet or aid the commission of offences. 6. Where civilian and military personnel have committed a crime other than a service offence, both be tried in civil courts. And 7. Parliament cannot duplicate offences prescribed in other acts of Parliament to introduce them in the UPDF Act. Colleagues, members of Parliament, the ratio from the above, with a sober appreciation of the provisions of Article 28 of the Constitution, leads to inevitable and incontrovertible conclusion that all persons, militant or otherwise facing criminal trials, have a right to appear before a competent, independent, fair, impartial court or a tribunal with a decision of the Supreme Court. The trial of persons with offences within the exclusive jurisdiction of the civil courts, particularly by the High Court. Military courts are not competent to try such cases. It goes, therefore, without saying that any trial will still be unconstitutional and will offend the principles of a fair trial. Accordingly, enacting the proposed legislation into law will be a legislation in vain. Common theme among justices of the Supreme Court Common themes among the justices of the Supreme Court was that the General Court Martial is a tribunal and should be kept as such. Right Honourable Speaker and members, let me conclude on this note. Court-martials should be specialized disciplinary tribunals with restrictive functions to handle disciplinary matters that are peculiar to and connected with discipline and regulations of the armed forces. By Justice Catherine Bamugemere, Justice of the Supreme Court, at page 41 of our judgment. Colleagues, members of Parliament, having appreciated that the second area of dissent has been appreciated, I would go to
Go to the third area of dissent.
Your Honor, Right Honorable Speaker, offending the doctrine of separation of powers. Modern democracies are typically organized around three branches of government, each playing a crucial and distinctive role. Adjudication in particular is a function and a preserve of the judicial branch of government. Overriding or intrusion would by in any of the other two would inevitably offend the Constitution. The judgment of the Supreme Court covers situations where military under the UPDF Act may depart from this position by only in a very exceptional circumstance that are consistent with demonstrable justification. The Chief Justice at page 78 to 79, quoting Nalwairo in his work, Improving the Administration of Justice by Military Court in Africa, an appraisal of the jurisprudence on human and people's rights, 2019. Held that a host of authorities, held that separations of power helps to provide sufficient safeguard to ensure fair hearing by instruments enunciated by the law on independence and impartiality of the court-martial, such as cardinal and core to the administration of justice. The minority are of the view that granting the military, through courts-martial, the unlimited power to try persons with offenses beyond disciplinary ones would be a violation to the doctrine of separation of power, beyond its function envisaged in Article 209 of the Constitution. Article 210 of the Constitution, pursuant to which the UPDF was enacted, did not envisage the establishment of a military and judicial function. Such an extension, therefore, can only be handwork of a overzealous but mischievous, stretched imagination, rooted, brewed, and bred in imperfection by proposing an amendment which doesn't meet the test of legitimacy, and we invite Parliament to reject this bill to this extent. 3-0, impartiality and independence of the courts. Right Honourable Speaker and colleagues, members of Parliament, the impartiality and independence are not decorative ideals. They are constitutional imperatives grounded on Article 28 of the Constitution. The right to a fair hearing, and Article 128 of the Constitution, independence of the judiciary. Military courts, as a creature of statutes, are subordinate to the constitutional principles and are bound by these standards. Article 128(1) of the Constitution also imposes a requirement as to the objective of the independence of the or tribunals, exercising judicial powers as a safeguard to a fair hearing. It states that in the exercise of judicial powers, the courts shall be independent and shall not be subject to the control or direction of any person or authority. The bill in clauses 35, 36, 38, and 45 provides for various amendments to the UPDF Act, specifically to the provisions establishing courts martial. It creates the following court martials: a unit court martial, divisions court martial, the general court martial. The bill removes the following courts and trial processes: A, the commanding officer or officer commanding; 2B, trial by superior authority; C, court martial, court of appeal; D, field court martial; E, summary trial. Despite the aforementioned, the bill did not respond to the orders and recommendations of the Constitutional Appeal number 2 of 2021, Attorney General versus Michael Kabazaruka, as far as independence and impartiality is concerned. Colleagues, I am persuaded to take you further to our next point of dissent, appreciating that you have read what we are talking about. Colleagues, I have seen the labor you've had to listen to these submissions because it is aided by legal gymnastics and quoting of cases. But please listen. Let me go to recommendations. Recommendations. The minority finds that the provisions of clauses 30 specifically proposes Section 117A. Proposed Section 117A is unconstitutional, irregular, and illegal as far as it allows the trial of civilians by military courts in the circumstances that are not exceptional. B, it extends to the jurisdiction of military courts. It extends the jurisdiction of military courts to the entire civilian population and to all offenses which ordinary courts are in position to try. C, the bill also extends military courts to cases reserved for specialized courts such as the High Court. D, the bill extends its service, extends service offenses to civilians. Minority cautions Parliament that the Supreme Court directed Parliament not to duplicate offenses prescribed in other acts of Parliament and introduce them in the UPDF Act, where therefore recommend that the same be rejected. 4.0, lack of public participation. The Constitution in Article 38, 1 and 2 thereof reaffirms the right of every citizen to participate in a fair Colleagues, various stakeholders were therefore locked out of the process due to this clearly cosmetic semblance. In the view of the minority, this did not meet the required standard of public participation. Indeed, apart from the Attorney General and the sponsoring minister, the committee interacted with only two other stakeholders, that is the DPP and Council Jude Biamukama. One would wonder why a matter of great national importance of this magnitude would only attract two external stakeholders. This is unprecedented in matters of this nature. On this account, in addition to other reasons given in the given, the minority invites Parliament to reject the bill to the extent proposed herein. This was the conclusion of the minority. Right Honourable Speaker, whereas reforms within the UPDF Act are necessary to address contemporary security challenges, such reforms must not compromise constitutional rights. Judicial independence or civilian oversight. We, the minority, persuade this Parliament to reconsider the provisions of the UPDF Amendment Bill 2025 to ensure they align to the principles of democracy, rule of law, and respect of human rights. Therefore, the minority unanimously are of the opinion that the General Court-Martial and other courts do not have constitutional jurisdiction to try civilians or adjudicate non-disciplinary criminal offences, even if committed by members of the Uganda People's Defence Force under Article 210 of the 1995 Constitution. Parliament's power to legislate for military courts is strictly confined to matters of discipline and removal of the UPDF. Members, military courts are therefore internal discipline bodies, not general criminal courts, and cannot override the constitutional mandate that all criminal justice, including a fair trial right under Article 28 and 44, lies exclusively with the courts of judicature.
Thank you.
Members, this was jointly and severally the report by the minority. Back to submit.
Thank you. Thank you so much. Honourable members, there are two minority reports. Not so, Chair. There are two minority reports.
Right.
Second one, I am not aware, and it offends the rules of procedure, Right Honourable Speaker.
Yes.
The Right Honourable Speaker, according to the official information we have, is that the opposition are officially boycotting this sitting. I would wonder how my colleagues are masquerading here.
Honourable. Honourable members, the opposition is in the house. Opposition is in the house. I see Honourable Kelo, Honourable Court, Honourable Olanya, Honourable Santa, Honourable Duru, who was ably presented a report, Honourable Namanya. Honourable members, Legal, did you get a report from?
I've just received a document. Someone came and dumped a document here, but I've just read it is a minority report of the Honourable Jonathan Odur. I was not informed what it was, but I've just read and realized it is a...
The mic did not pertain.
After all, it's a minority. It's a minority.
Yes, Fox.
Thank you, Right Honorable Speaker. Right Honorable Speaker, I rise to move a motion.
No, there is still an issue of the minority of Honorable Dole, which the chair said was not given to him.
But, Right Honorable Speaker.
Honorable, yes, yes, Honorable Minister.
Right Honorable Speaker, since NRM believes in democracy, we should allow Honorable Dole present to the House.
Honorable Chris.
Thank you very much, Right Honorable Speaker. We make the rules ourselves as the Parliament, and we must respect our own rules. Everybody to abuse provisions of our rules. If the rules require that a member dissenting must formally process his report, give it a chair, let it be. Let's not allow abuse of our rules. And therefore, if he has not followed what the rules provide for, we should not listen to that report.
Honorable members, let's not be seen to be suffocating in a member. Let Honorable Dole come up with this report and give us a summary of this report, his areas of dissent. Let him do it.
Thank you. Thank you very much, Right Honorable Speaker. Madam Speaker, for the record, this morning I made a phone call to the chairman of Legal and Parliamentary Affairs Committee, and I told him on the phone that I have a minority and the chair is here. Secondly, when I reached Parliament, I again notified him on our platform, and then I filed this report with the clerk of our committee, who duly submitted to the clerk of Parliament. It has been duly stamped as received. So the record should show that I am not smuggling, I'm just complying with the rules. Madam Speaker, before I read, I beg these two situations for members to bear with me. First of all, as Honorable Ochero rightly observed, the leader of the opposition, my boss, has led a walkout from this city, and I am his shadow minister for justice and constitutional affairs. You can imagine the situation I'll be. I may finish and I get fired. So allow me to present this report here. Secondly, in tense moments like this, you would beg that members bear with me. During the ruling in the Supreme Court at myself and many others against the Attorney General, when their lordships had judged 3 against 3, the last judgment was by the Chief Justice then, Bart Katurebe, and when he had begun to read, he informed us that his glasses and the eyes had a problem, and he needed to be rushed to South Africa immediately. I pray when I'm reading this report, my glasses don't fail me. Having said that, Madam Speaker, introduction. This is a minority report in dissent of the majority report of the Joint Committee of Legal and Parliamentary Affairs and the Committee of Defense and Internal Affairs on the Uganda People's Defense Force Amendment Bill 2025. This minority report is brought under Rule 215 of the Rules of Procedure of Parliament, areas of dissent and statement of reasons for dissent. The minority restricts the areas of dissent majorly on the policy and principles, defects in the existing law, remedies proposed in the bill, and specific provisions of the Uganda People's Defense Forces Amendment Bill 2025, touching the courts martial and related matters, including the shadows approach. In this minority report, It presents specific thematic areas of dissent, the reasons for the dissent, the applicable subsidiary legislation, and the lead judgment in the Supreme Court, Attorney General versus Michael A. Kabaziguruka, Constitutional Appeal number 2 of 2021. Therefore, Right Honorable Speaker, each one sentence, paragraph in this report has been carefully considered by the minority for justifying the dissent from the main report of the committee. The minority prays that time be allowed for this report to be presented to the House, both verbatim and seriatim. Thank you. Preliminary and substantive discussions on points of law. In this report, the minority raises several points of law in both preliminary and substantive forms. The minority submits that meaningful debates and decisions of Parliament can only take place after the presiding officer has disposed of, by way of a formal ruling, with reasons all the points of law raised. The presiding officer should not be tempted to sweep under the carpet, fail or casually dismiss these important issues of points of law raised by the minority. In short, the minority invites the full attention of the presiding officer during the presentation of this report and prays for the rulings to be delivered on record in a timely manner before debate ensues. Breach of Rule 75 of the Rules of Procedure of Parliament on sub judice. During the consideration of the bill, the Ugandan Law Society brought to the attention of the committee and Parliament an active court case in the East African Court of Justice, which court decisions are binding on Uganda as set out in the landmark precedent case of Among A. Anita versus Attorney General of Uganda, and another, reference number 6 of 2012. I produced the letter dated 14 May 2025, and it is addressed to the clerk to Parliament and reads as follows. Reference, the Uganda People's Defense Amendment Bill 2025. Greetings from the Council, management, and staff of Uganda Law Society. In response to your invitation to meet the Joint Committee on Defense and Internal Affairs and Legal and Parliamentary Affairs for consideration of the above captioned bill, for which we are grateful, this is to inform the Joint Committee as follows. 1. The Uganda Law Society received your invitation letter today at 11:50 a.m., scheduling a meeting for 12 p.m. on the same day. With the greatest respect, the time frame is manifestly inadequate for a thorough consideration of the 150-page bill and is incompatible with democratic accountability. 2. Be that as it may, the Uganda Law Society hereby brings to your attention reference number 14 of 2025, Uganda Law Society versus the Attorney General of the Republic of Uganda, pending before the East African Court of Justice. Discussing the bill's provision on military courts would inevitably breach the sub judice rule, contrary to Rule 75 of the Rules of Procedure of Parliament of Uganda, Statutory Instrument number 43 of 2025, and Article 38, Sub-Article 2 of the Treaty for Establishment of the East African Community, and potentially contravenes Articles 2, 20, 79.3, 92, 126.1, 128.3, and 287 of the Constitution of the Republic of Uganda. 3. Given the pending litigation, we respectfully request the Joint Committee to urge government to pursue amicable resolution of the dispute before engaging Parliament and on the contested matters. The Uganda Law Society welcomes the opportunity of another invitation to discuss the rest of the bill. Yours, it is signed by a one Asimwe Anthony, who is the Vice President of Uganda Law Society. I don't know for what reason why the President was not available to sign. I now beg to lay on table the copy of duly received by the Office of the Clerk, as well as a copy of the reference number 14 of 2025 Uganda Law Society versus the Attorney General of the Republic of Uganda. Madam Speaker, this document is already part of the minutes laid by the committee. If it's not there, I have a copy that I can lay. In the same vein, the minority also draws to the attention of the Right Honorable Speaker of Parliament and Parliament the constitutional application number 01 of 2025, Male Mabirizi K. Kiwanoka versus the Attorney General, filed in the Supreme Court of Uganda on 14 April 2025. And the same has been duly served upon the respondent who is present in this sitting. The gist of that application is that the Supreme Court should determine whether the action of the respondent, who is the Attorney General and Government and Parliament, of proposing and consideration of the Uganda People's Defense Forces Amendment Bill 2025, providing for trials of civilians in the court-martial, is contemptuous of the judgment of the Supreme Court in Uganda, in Supreme Court of Uganda, in Attorney General versus Michael, which I have already cited fully. The constitutional application number 01 of 2025, as referred, filed in the Supreme Court, has already been duly served. The respondent, the Attorney General, is present in this House and can confirm or deny the existence of this live case. All that the minority is belaboring by this submission is to demonstrate by all standards that there is a live and active dispute, not only before the East African Court of Justice, but also Uganda's highest court, the Supreme Court. It will be quite embarrassing for Parliament, an institution central to democracy and the rule of law, to carry on with the consideration of the Uganda People's Defense Forces Amendment Bill 2025, well aware of the court cases that touch on the subject matter of the clauses in the bill. The finding of the minority. The minority finds that Parliament proceeding to consider the clauses of the UPDF Amendment Bill 2025 touching the subject matter of trial of civilians in the court-martial undermines the core tenets of the rule of law, the doctrine of mutual respect for separation of powers between the executive, legislature, and judiciary. The next is on contrary to Article 92 of the Constitution of Uganda.
awo njagala tulambulule ebisookerwako embanga njagala okukola ssente kuba bangamba okufuna si kyekituufu okuzikola kyekituufu obanga njagala okuzongera mu bizinesi yange
oli ku MRI TV eddoboozi ly'omuvubuka. Oli ku MRI TV eddoboozi ly'omuvubuka.
Okwebaza Katonda nti ampadde omukisa okujja wano.
Oli ku MRI TV eddoboozi ly'omuvubuka.
Mu ggwanga nga ebiseera ebisinga obutamanya.
Oli ku MRI TV eddoboozi ly'omuvubuka.
Nebakera ku makya ne baavuwala abantu bangi.
Oli ku MRI TV eddoboozi ly'omuvubuka. Oli ku MRI TV eddoboozi ly'omuvubuka. Oli ku
kumanya wa awatuufu n'ebintu by'olina okukola okwetegeka okugamba nti kati ntuusi bwe tuba tusomesa ekintu ky'okufuna ssente abantu obutakyerabira tukigeraageranya n'omugole tosobola kukeera ku makya n'ogamba ekyangenda kufumbirwa wabeerawo okutegeka okubeera ng'omuntu bw'anaakulaba olinga ekyokulya ogwanidde okuwasa bw'oba mukyala so obuzibu obusinga nti abakyala bo baba balowooza nti bw'aba ayagala ssente
TV eddoboozi ly'omuvubuka oli ku MRI TV eddoboozi ly'omuvubuka oli ku MRI TV eddoboozi ly'omuvubuka oli ku MRI TV eddoboozi ly'omuvubuka oli ku
The next president, as per the law, shall be the commander-in-chief, boss of the court-martial. This house may have
tulina abakyala abasomye naddala mu ezo incubation centers mu training ziye kyetuyita financial literacy oba okumanya n'okutegeera nga banks zibakubira waki era bebo bebamu banks zonna bezeetooleramu kubanga bategekeddwa naye ekintu ekirala saagala ate abantu bakifune bubi tubadde tukyogera abannayuganda bangi n'abakyala nga mwebali abannayuganda bafulumya okusinga bwe bafuna so tosobola n'omulundi n'ogumu kugamba nti ofuna kangeze oba omuntu wa musaala kuba ogwo gwe mulimu gwenkola buli lunaku ofuna $1.5 million net naye n'ogenda n'osula mu nnyumba y'M8,000 olwedde ekyokugaggawala eyo decision gye wakola ey'emu ngenda kusula muyenga ng'ate wandisuze kibuli olwedde akukaba ekyo kiba kizibu kinene ekizibu ekirala kye tulina
Madam, please remove it. Yes. This is a one member's report signed by me, and I can amend it. I want to withdraw. That's what the point I want to make.
Withdraw. I'm not part of that.
That although I had said that the names were in the public domain, public domain. Withdraw. I beg to withdraw.
I have my own right.
I beg to withdraw and delete and amend this report by deleting the name Right Honorable Anita Among Annette from this report. And I accordingly withdraw and apologize to you, Madam Speaker. Please, the record has it. Please, I invite this House to carefully reflect on each one of them, their soberness, fidelity to the law, ideologies, actions, sentiments, service records, and imagine what point is dissent is understanding of the judgment of the Supreme Court in that case. Right Honorable Speaker, during the consideration of the bill in the committee, an issue arose as to whether there was a lead judgment to inform the consideration of the bill, or all judgments of the quorum mattered. The learned Attorney General informed the committee that the judgment of Honorable the Chief Justice, as is the lead judgment, whose final orders and recommendations guided the drafting of the bill. Whereas the minority considered the other judgments as equally important, in as far as several rulings therein, the minority, for purpose of harmony, agreed with the Attorney General to restrict discussions around the lead judgment of Honorable the Chief Justice, Alphonse C. Owindolo, who listed 6 specific issues that the Supreme Court was required to resolve, and the issues are as follows. The first was whether the court-martial are courts established under the Constitution or are mere tribunals. 2, whether the court-martial can be or are independent and impartial within the meaning of Article 28 of the Constitution. Whether civilians can legally be liable to face trial in the court-martial for disciplinary offenses herein called military, disciplinary or service offenses stipulated in Part 6 of the UPDF Act. 4, whether civilians can constitutionally or legally be tried in the courts-martial for civil offenses not comprised in Part 6 of the UPDF Act but are instead provided for in other legislation. 5, whether it is constitutional for persons subject to military law to be tried in the court-martial for offenses outside the UPDF Act, herein called civil offenses. 6, whether it is constitutional for civilians to be tried by the court-martial as principal for offenses under sections 1191H of the UPDF Act. Yet all those also exist in the civilian offenses. Right Honorable Speaker, the minority has found it necessary to briefly highlight the decision of the Supreme Court in each of the questions, as this will be extremely important. First, in refreshing the memory of the members, then secondly, and most importantly, guiding the members to properly direct their minds during the debate on the principles and justification of the bill. On the first issue, number 1, whether court-martials are courts established under the Constitution or a mere tribunal. In answering this question, Right Honorable Speaker, which answer was agreeable to the rest of the panel, Honorable the Chief Justice Alphonse C. Owindolo wrote on page 44, paragraph 15 as follows: I would therefore hold the General Court-Martial is not merely a complementary court to civil courts. It is established as a court which is, however, seized with specialized jurisdiction. The take-home from this answer is therefore twofold. One is that the Supreme Court recognized the existence of court-martial as a creature of law. And secondly, but most importantly, its special status, implying it is meant for specialized cases only. I now quote the learned Attorney General of Uganda in a letter which I also beg to lay, I believe is part of the documents laid, written on the 3rd February 2025, addressed to the Honorable Minister of Defense, addressed to the following: Honorable Minister of Defense, the Chief of Defense Forces, the Chief of Joint Staff, and Director of Public Prosecutions, in paragraph 2 on page 2 and paragraph 9 on page 3, reproduced below. This, I quote what the Attorney General wrote. Section 197, now Section 195 of the UPDF Act, which establishes the General Court-Martial, is duly established under the law as a competent court, is constitutional. The Attorney General said, our understanding of the above declaration is that the General Court-Martial is duly established under the law and its existence is consistent with the Constitution. However, it must be clothed with the following attributes. A, members of the General Court-Martial must be persons with requisite legal qualifications. B, the members of the General Court-Martial should be independent of the command and have security of tenure. C, there should be adequate time and facilitation in the preparation of defense by an accused person, as well as a right of an accused person to due process and an appeal in capital offenses. D, the convening authority must lie with the General Court-Martial, which guarantees institutional independence from the authority prosecuting the case. This is what the Attorney General advised, and it will help us when we come to closes. It is Attorney General further writes, sections 2, 179, 1191 H and G, now respectively 177, 10X, 1171 H and G of the UPDF Act are unconstitutional, since they confer blanket jurisdiction on court-martials to try civilians. Our understanding, this is what the Attorney General wrote, our understanding, the understanding of the Attorney General of this declaration 7, 8, and 9 by the court is that civilians cannot be tried in military courts. Our understanding of these declarations 7, 8 and 9 by the court is that civilians cannot be tried by military courts. I quote from the Attorney General. The minority recognizes the mandate of the Office of the Attorney General under Article 1193 and 4 of the Constitution of the Republic of Uganda, to wit, shall be the principal legal advisor of government and to give legal advice and legal services to government on any subject. It may be recalled, Right Honorable Speaker, that in both the original constitutional petition, number 45 of 2016, Honorable Michael A. Kabaziguruka versus the Attorney General in the Constitutional Court, and in the Constitutional Appeal number 2 of 2021, the Attorney General versus Honorable Michael K. The Attorney General diligently and professionally offered legal services representation in court and lost all the arguments except the legality of existence and creation of the court-martial. However, how then does the executive and even parliament expect the same learned Attorney General to again go back to the Constitutional Court and Supreme Court to defend the same issues which he argued and lost? It must be very burdensome, tiresome, hopeless, and frustrating to be a lawyer to the government in such scenarios. Sympathies to the learned Attorney General, Honorable Kiwanuka, and the team of learned friends in the chambers of the Attorney General who prosecuted the case. Can they even dare face the same court again on the same issues already decided by court? Finding. And I must say, on a lighter note, Madam Speaker, a former Attorney General William, Senior Counsel William Biaruhanga, I'm reliably informed, asked to be excused from executing role of Attorney General. Then another Deputy Attorney General who was with us here, Honorable Mwesiga Rukutana, immediately he left this role. He had the energy to marry even a young wife. So it is really burdensome to be an Attorney General.
Honorable Duru, you're going personal. Please.
I withdraw.
She has nothing. I mean, what's wrong with marrying a wife?
Finding. Huh? I withdraw, Madam Speaker. Finding. The minority, therefore, finds that there is no legal basis to provide for trial of civilians in the military court as decided by the two highest courts of Uganda, Constitutional Court and the Supreme Court. The minority further finds that there is no political, ideological, and security narration to justify enactment to provide for trial of non-military offenses in the court-martial, and therefore is shallow, unreasonable, and unconstitutional. Court-martials, as found by the Supreme Court, are established legally, hence there is no need to re-establish it. Court-martials, as found by the Supreme Court, and this is what I want members to pay attention to, are already established legally, hence there is no need to re-establish it. The question of restructuring of the court-martial is necessary, but as shall be later pointed out, not possible through provisions of the proposed bill. Subordination of the court-martial. That's the next point of dissent. The Honorable the Chief Justice, Alphonse C. Owindolo, in his judgment, found as quoted below. Additionally, I open the quote, additionally, as already noted, the General Court-Martial and other military courts are all subordinate courts. See the case of Attorney General versus Uganda Law Society, Constitutional Appeal, number 1 of 2006. However, I do not agree with Mulenga, Justice of the Supreme Court, finding where he held that the General Court-Martial is subordinate, but not lower than the High Court. According to the Black Laws Dictionary, Brian A. Garner, 8th edition, subordinate means